28 dockets, they would.
Next on my speakers list is Honorable Malema.
Thank you very much, Chairperson of the NCOP.
A team so that they deal with it.
Good morning everyone. Good morning, Advocate Maema.
Good morning, Chairperson.
Advocate Chauke, good morning. Advocate Maema, you proceed with your evidence under oath.
That is correct, Chairperson.
Thank you. Advocate Nkcukaitobi.
Thank you, Madam Chair. Madam Chair, in the last 5 minutes, there has been some progress because what has been in dispute has now been accepted that is no longer in dispute about the contents of the dockets that have been analyzed. We analyzed 7 yesterday. We had to make a decision whether to analyze more. My learned friend tells me that they will not be placing that material in dispute anymore. But perhaps he should speak for himself.
Advocate Mchene,
Yeah, Madam,
on behalf of the evidence leaders.
yes, Madam Chair, we have discussed it with Advocate Mahlomayane, and Madam Chair, we will not be disputing the contents of the dockets, those that have been analyzed and those that have not been analyzed. We accept that the contents of those documents are as they are, and the panel can take notice of them.
Do not know whether the NPA team would like to say anything. Please come forward to, you can borrow us that moving mic.
Thank you, Madam Chair. We're saying that not at this stage.
What do you mean, not at this stage?
That the dockets that are remaining would be contested.
You need to make up your mind because it will make it difficult for them to make an assessment whether it is important to proceed with the remaining part of the dockets, particularly because they may plan to deal with the different matter, and this witness may be excused sooner than we had anticipated.
As of yesterday afternoon, the discussion with the evidence leaders was that perhaps they should request a list of issues that the Advocate Chauke's team intended to lead evidence on, so that the team can decide whether they would need to have that proceeded with or that they accept the contents as they are and they will not dispute. anything in relation thereto. So when the discussions were made, there was no indication whether there will be an agreement on that aspect. So matters were left at that.
Were you part of the discussion 5 minutes ago?
No, I was not part of the discussion 5 minutes ago.
Yes, I appreciate that your senior advocate Hali is not here.
Yes.
I'm just affording you this opportunity because you are representing the NPA, and it doesn't appear to me that there can really be any dispute because the dockets are what they are, as they stand, unless, of course, you're going to call evidence to the contrary.
Thank you, Madam Chair. Unless perhaps I get just quick instructions from my senior and client. But as I say, the indication was that at least if we get pointers of issues that they still needed to lead evidence on, and the team would decide whether they want to accept and admit the evidence as it is.
Can I just check? You do have copies of the dockets?
Yes. Yes.
And we got the dockets from NPA.
Yes. Yes.
Obviously, you would have gone through them.
Yes.
And you would have identified issues that you dispute from
Yes.
the dockets.
Yes.
So maybe instead of having the Chauke team that is now in the process of leading evidence, having to make time to write down all the issues that they intend to lead, because obviously if they have 28 dockets, they would intend to lead evidence on 28 dockets. But it would be better if the NPA were to say in docket, in count, docket number, case, whatever, we dispute 1, 2, 3. And yeah, because the documents are yours, they come from you. So you should know them better than us. I take it, maybe it would be better if you were to still persist that you are going to oppose some of the issues. Maybe you should just alert the Chauke team so that they deal with it, and we obviate the need to have to recall a witness or to have to revisit any evidence. Thank you, Chair.
Thank you, my sister. Yes, I agree. And but for now, we will proceed on the basis of your for now.
Yes.
With a view that you will revert. You understand why we are here.
Yes, I do, Madam Chair, and I appreciate that if we can proceed on the basis that at this stage at least there is no indication on what we are going to need further evidence to be led on, and be allowed later on to indicate.
The affidavit of Mr. Maema is in front of you.
Yes.
You know exactly what he's saying about those dockets.
Yes.
If there's any issue that arises from those aspects that he's raising in his affidavit, which we now have, all of us have read, you should be in a better position to say to Advocate Ngcukaitobi, we will dispute this and that, so that then he can focus.
That is so, Madam Chair. We will do that.
Yes, thank you. Advocate Ngcukaitobi.
Thank you, Madam Chair. Advocate Maema, good morning. We will...
Let me remind him that he is under oath. I beg your pardon, Advocate Ngcukaitobi. Counsel, you are still under oath.
That is correct, Chairperson. Thank you.
Thank you, Madam Chair. We will
Good morning,
skip,
Chairperson.
yes, we will skip everything from the last case that we dealt with, which was the case of Peggy Temba, to paragraph 345.
I am there, Chairperson.
The heading there is legal framework for racketeering.
That is correct, Chairperson.
Yes. Now, the a number of concepts that one needs to dissect in dealing with the concept of racketeering. The first one is the concept of an enterprise.
That is correct, Chairperson.
Can you explain why you believed the Nkcukaitobi unit qualifies as an enterprise under the poker legislation?
Chairperson, the concept of an enterprise, I deal with it on page 1-86, paragraph 350.3. An enterprise in terms of the poker legislation is defined to include any individual, partnership, corporation, association, or other juristic person or legal entity, and any union or group of individuals associated in fact, although not a juristic person or a legal entity. So the enterprise is that common vehicle through which all the offences are committed, but it is the members of the enterprise might differ from incident to incident, but the fact is the enterprise advances the objectives of the enterprise.
Yes. Now, there is also an associated topic around the concept of an enterprise, which is whether or not it's necessary in law to qualify as an enterprise, that it must be performing illegal or unlawful acts. Remember that the finding made by the DeKok panel is that Nkcukaitobi is not an enterprise because it was established for lawful purposes.
Well, Chairperson, you find an institution established for lawful purposes, which is just a cover. But when in real fact, there are other businesses that they engage in which attract criminality. So whether it is a lawful institution or an unlawful institution, it can be an enterprise.
Yes. Then there is also another element to it, which is who is inside the enterprise.
Yes.
And how do you decide who is inside the enterprise? Can you explain to the panel how is that exercise to be undertaken?
Well, you look at the day-to-day activities of the enterprise. Like you say, Council, the members of the enterprise on any given incident might be different. But whenever an individual participates in the activities of an enterprise and advances the objectives of the enterprise, then he associates in fact with the enterprise.
Yes.
So you can charge him as part of the enterprise.
Yes. Thank you. Now, just to apply then these concepts of an enterprise to Nkcukaitobi
Yes.
specifically, can you help us with that?
Chairperson, we as a team, as a prosecution team, my team, together with the police, the DPCI, and IPED, as well as Advocate Musing from National Office, we spent, I think, almost a week debating this issue of an enterprise. When one looks at the provincial organized crime, we thought, particularly because of the involvement of General Johan Boysen at provincial level, we thought, could the entire provincial organized crime be an enterprise? But when you looked at the role of Colonel Aya, who was then removed, and then Boysen comes down from province to to assume the position of AIA. And the serious violent crime section of Ketomena is the one that conducts all these activities. Then we then concluded that the serious violent crime section in Ketomena is actually the enterprise. And because Johan Poison managed their activities, supported them, and made sure of their continuity, we then settled for serious violent crime based at Ketomena as the enterprise.
Yes. So the one way of looking at it, so what happens, for instance, there are some scenes that I've noticed here where the members of the National Intervention Unit come and play a role.
That is correct.
Yes. And then there are also some scenes where you'll find a member from, we looked at one 2 days ago, from Granscope,
Yes.
comes to the scene, and then Keitomano comes and they remove them.
Yes.
So although you've got in total 28 of these incidents,
Yes.
23 of the incidents, 28 deceased, it expands and contracts by the addition of people from outside of Keitomano.
That is correct.
Just explain that. How does one deal with that?
You see, for one to be part of the enterprise, you must participate in two or more incidents. So in some of the incidents, we find one or two who participates in one or two. But we to be charged with 21E or 21F, we needed a member of the enterprise to participate in more than one incident.
Yes.
Yeah. So those that we charged with 21E and 21F, we are convinced that they had a role in more than one incident.
No, we'll come to the participants
Oh.
because that's a different topic. I'm still trying to understand the enterprise itself, how you saw it. So you say that the inner core of this enterprise was the Serious and Violent Crime Unit of Keitomano.
That is correct.
And we know the members of that unit.
Yes.
Yes. But I'm saying sometimes if there is someone from outside of that unit,
Oh, now I get you. Yes. Who then comes?
Yes.
Then you look at the role of that person.
yes,
And how the role of that person, what do you say, advances the objectives of the enterprise.
yes,
Yes. Yeah. And if whatever role that he participated in advances the role of the enterprise, then you can charge him.
yes. So, but how would you know that his participation? Because you see, if you said, listen, my enterprise is this group of people,
Yes.
because they are pursuing a same object over a sustained period of time.
That is correct, yes.
But now there's someone from outside who comes in on one or two occasions. You say, well, that doesn't change the character of the enterprise. I suppose.
That is true. Yes. So what you do is you then charge him with the role that he played, not in terms of 21E or 21F, but as you specifically include him in the incident where he was
I
physically
see.
involved.
So that would not be a racketeering charge.
That would not be a racketeering charge. Yes, it would be a predicate offence.
Because the racketeering charge requires that enterprise to be
That is
defined.
correct. Yes.
So if you charge someone who came from NIU or NIT, it will be because they've committed murder.
Yes, they were present at the particular scene where one of the deceased was killed.
But not because they were in the racket.
Not that they were in the racket. That is correct, Chairman.
In that event, he could be charged under the common purpose principle.
That is correct, Chairperson.
Yes. Thank you very much. Now, all right. Is there anything you want to add on the definition of an enterprise and why you believed it applied to the Serious and Violent Crime Unit of Keitomano?
Chairperson, I think we have dealt with it, yes, sufficiently.
All right. Thank you.
Thank you.
There are further concepts that must also be dissected. The first one you deal with in 350.1, pattern of racketeering. Just explain the concept. We will deal later with how it applied to Keitomano.
Chairperson, in terms of Section 1, a pattern of racketeering activity is defined as the planned, ongoing, continuous, or repeated participation or involvement in any offence referred to in Schedule 1, and it includes at least 2 offences referred to in Schedule 1, of which one offence occurred after the commencement of this Act, and the last offence occurred within 10 years, excluding any period of imprisonment after the commission of such a prior offence referred to in Schedule 1. So the pattern of racketeering activity would look at those the commonality in all the incidents. When you say, for instance, in Ketomena, one thing that is common in most of the incidents is raiding early morning when people are asleep, but predominantly one similar character in the manner of their conduct is planting of a firearm, placing a firearm at a place where the deceased is killed to create that threat threat impression. You'll remember at one of the incidents when they were in the Kumbi, Moster ran back to the Kumbi during the raid to go and get his Bombay, because the Bombay is an essential element of the pattern of racketeering activity.
You know,
After
I thought
the
of
shooting,
this word Bombay yesterday. In the townships, it's used to indicate something fake.
yes,
But in the villages, it's actually not Bombay, it's Mbai, which is a machine gun.
yes.
Anyway, I thought, so it's actually Mbai.
Yes, but you see the Ketomena guys refer to it as Bombay.
Yes.
Because what it signifies is a spook,
Yes.
something that was not there, but that is there.
Oh, I
So
see.
it wasn't there during the commission of the offence, but it just suddenly appears. So
it
they
was
make
used
it
properly
appear
as fake.
as fake. They make it as fake. That's how we understood their concept of Bombay.
Oh, okay.
To
So
me,
it's
yes.
the Bombay gun.
It's a Bombay.
It's a pretend gun.
Pretend, yes. It wasn't there, but it's there.
No, I understand. All right, but let's just come back then to this concept of a pattern. So you say there has to be a similarity in the activities of the group that is
Yes.
participating in the enterprise.
Yes.
And you've identified 2 similarities, but we'll come back to those. But I just want to come back to the words of the statute. So the first one is the planned.
Planned, yes.
Yes, let's just talk about that. What does that entail?
Well, planning it's a concept that we have in conspiracy. The coming together of individuals planning to achieve a particular objective. So there must be some coming together of minds. We come together and we plan and we say, this is what we hoping to achieve.
And why do you say that there was planning in respect of the SVC of Ketomana?
Chairperson, there was planning. They have to ensure that they have vehicles, they have equipment, they are able to execute, and yeah, there was a higher degree of planning in the activities of Ketomena.
Yes. And that's exhibited by the degree of organization in the way in which the executions took place.
That is correct. If you look at consistently most of the scenes, Eva would consistently be used to work on the scenes and to clean the scenes up. And there's a penetration team.
Yes.
Penetration team is those that get to the door, they knock, and we call them the scope and boboza. They break down the doors. Those are the experts. And we have 1 or 2 who are good in shootists, who excel in target shooting. If they want to shoot your ear, they will shoot your ear. If they want to to shoot your fingers that are holding the gun on the holster. They will do that. So there is a particular plane, and there is particular individuals that are given specific roles that they must execute.
Yes.
Yes.
I mean, I suppose even the concept of planting a firearm, that's not a random thing. That's
It's not a
also
random
it's
thing.
part of the...
It's part of the plane, because there you see monsters running back to the Kumbi. Underneath the driver's seat of the Kumbi, there is a bag containing firearms, and he picks one there, and he goes to the scene, and he throws it on the scene.
What about the identification of the targets to be executed? Is that part of the plan?
It is part of the plan, Chairperson. It started when they came back from Granscope.
Yes.
Yes. Because after Reddy was killed, there were two that were killed prior to Congo.
Yes.
And after Congo, they said, no, it's enough. We're not going to let criminals in KZN take over the province. We will deal with them, and we will deal with them decisively.
Yes.
So the plan started just after the killing of Soup Congo. They said criminals are not going to take over in KZN. But it is right for the police to say criminals can't take over. Yes, but what do? You make sure that you collect evidence lawfully in terms of the Constitution, you present the evidence before court, and you convict the criminals.
Now, I mean, you've said twice that this began after the murder of Superintendent Kongo.
Yes.
There is the evidence of Mr. Danikas, who traces the events from 2001.
Far earlier, yes. Yes.
Which was one of the pieces of evidence in front of you. What do you make of that?
Chairperson, we looked at that evidence, and in terms of poker, it is similar fact evidence that you can lead that is admissible. So even incidents that happened before, although we have a period that we focus on, but you can refer to a previous incident, you can refer to a previous conviction. This is one of the instances where even a previous conviction is allowed to be disclosed before conviction.
No, but I'm saying in terms of when this conduct of Kaito Manu began, when you say it began after the murder of Superintendent Kongo, there is a witness who actually traces it earlier than the murder of Superintendent Kongo. I understand the issue of similar facts. We can deal with that later, but
yes.
For now I just want to deal with your point that the planning to execute, which we are still dealing with the concept of planning, the planning to execute took place after the murder of Superintendent Kongo. How do you place that in the context of what Mr. Danikas is saying, that actually we had been torturing and killing suspects since 2001?
That is correct. Chairperson, I'm saying it started early, but the tip of the iceberg was the killing of Supcon. Because what happens when it was happening prior to 2008 at a snail pace. After the death of Supcon, you see it picking momentum, and even not only picking up momentum, also the vigor and the enthusiasm, the rigorousness increases.
Yes. Thank you very much. Then you have the second word. It's planned. It's also ongoing. What does that refer to? Ongoing.
Ongoing says it must be. It must happen over. It mustn't start and then stop. Starts. That characteristics denotes that it's something that takes place over a period of time.
Yes. So in other words, it's not one incident of a policeman killing a suspect, but it's several incidents.
Several unending incidents. Yes.
Yes. And then those words appear to be similar to continuous or repeated, which is also in the statute.
Yes.
Can you just explain what, I mean, because ongoing, continuous appear to be meaning the same thing. and repeated also seems to be meaning the same thing.
Yeah. Well, all that they denote is that it's like an object falling from the mountain. It just keeps on rolling. So it is incident after incident after incident. So they are continuous, repeated, ongoing. Yes.
Yes. Now I want to ask you here, because there are some findings made in the DCOC report which are in conflict with your approach. Finding one is that continuous means it must be unending into the future. So in other words, you can't say it was continuous between 2008 and 2011, which was the scope of your indictment. It must also be continuous beyond 2011, way into the future. Now, what do you say to that?
No, it is an incorrect analysis of the principles, because what would happen, although it is ongoing, continuous, and repeated, something will happen that will apply brakes to this object that is rolling down. If it hits a rock and gets stuck, or if the car that is going, the petrol finishes, then at some stage it comes to an end. But the mere coming to an end of an operation, that does not mean it disqualifies it from.
Yes.
from
Are there also not
from the characteristics?
Yes, serious implications of their finding, which is if a person or a group of persons who constitute an enterprise commit acts of racketeering between 2005 and 2010, and they stop, maybe the leader of the enterprise is killed.
Yes.
The NPA then comes in 2011. On this concept that it must be continuous into the future, what would happen?
Then it would mean you disqualify yourself from dealing with that as an enterprise.
Yes.
So it doesn't make sense.
Yes.
Yes.
Now, is there anything to be added on the word repeated? We've dealt with continuous.
Repeated also, it's the same, over and over again, thing happening over and over again.
Yes. Now, is there anything you want to add on continuous, ongoing, and repeated in relation specifically to Cato Manu that you haven't said?
No, Chairperson. What we saw their conduct fitting the definition of a pattern of racketeering activity as defined in poker. And this was a debate that we had amongst deputies, among senior state advocates, amongst General Mabula, Mr. Engars. Although the concepts themselves are not very, the police do not speak this concept. Prosecutors also do not speak this concept. I can assure you that if you go to the management of NPA, where Mr. Chauke was part, and say, define some of these things, they will not be able to, because they are not people that are working day to day with this kind of things. The people that are working day to day are organized crime prosecutors within DPP offices.
Yes.
If I may, on that, it means finally, when all is done and the matter is in the court, it's a matter for interpretation by the court.
Chairperson.
Applying the law to the facts?
Yes. Chairperson, what happens, we say, well, at the law school they talk about the art of persuasion. So I take my understanding of racketeering and the principles, and then I must convince my judge to see it the way I see it. I must persuade my presiding officer to see the facts the way I see them, and to apply the law in the manner that I want, that I see should be applied.
Yes.
And in relation to these matters, that will be more of the case in the criminal prosecution?
That is correct, Chairperson, yes.
One of the conclusions by the DCOG team is that if indeed there was racketeering towards 2012 or 2011, the number of people killed went down, so that indicated that the enterprise is dying, and therefore there is no need to continue with racketeering charges. I may not be quoting it verbatim, but I know that that is one of the conclusions that they came to.
I remember so, Chairperson, yes.
Is that the correct conclusion?
That is not the correct analysis of the principle. I differ from it with the greatest of respects.
I think my junior will find that portion, but it's exactly as you remember, Madam
Yes.
Baloimer. Yes, yes. Well, explain why you differ. That's the point of the question.
Chairperson, the fact that crime goes down, or the regularity of the occurrences just go down a bit, is not an indication of the conclusion or the non-existence anymore of the enterprise, because all that the law requires is, let's have one or more incidents that are continuing, that are ongoing. If I have one or two incidents that are, no, not one, two or more, that are continuous, that have a pattern, that are repeated, then I'm squarely within the definition in poker, and I'm fully entitled to proceed on a racketeering charge.
Yes, the passage that is relevant. I'm not sure if the DCOG report is in your bundle. It's not. Okay. I just wanted to be brought to your attention so that I can reference specifically paragraph 190.6, which is page 69 of the DCOG report.
In Chairperson, in which file do we find the DCOG report?
I think just use mine. I've got two.
Thank you.
Yes, Madam Chair, I'm not sure where the panel has it.
We have those loose ones, but they are lying somewhere. We will find that. You can go straight to the paragraphs.
Yes. Thank you, Madam Chair. So if you go to page 69 of the report, the pages are at the bottom left.
I see them, Chairperson.
Paragraph 190.6. Can you just read that for the record?
Paragraph 190.6.
Yes.
If one has reference to the evidence as contained in the dockets, the alleged enterprise was on the verge of extinction. In 2011, the accused are only charged with 2 racketeering acts as compared with 9 racketeering acts in 2008. To show a continuity, the racketeering acts must include a specific thread of repetition extending indefinitely into the future.
Yes,
Yes,
that's the question you have to answer. Why are they wrong there?
Chairperson, when you look at and that's in my view just basic interpretation of statutes by Cochrane. When you look at the entire tenure of the legislation, the entire legislation, it is intended to prevent organized crime. perpetuation of organized crime. Now, when for one reason or another, the crime stats goes down, you cannot say, well, because the fancy boys are no longer committing offenses as regular as they used to do. Now I'm not charging them with racketeering. So the regularity or the extent of commission of these offenses does not necessarily mean you have reached your goals. So even if the specific threat of repetition does not extend indefinitely, the fact remains the offenses are being continued. So my view would be that even though the continuity of the racketeering acts are subsiding and not continue indefinitely, it still fits the definition of the definition that we find in the legislation.
No, but I mean, assume for the benefit of the Tikok panel, the best argument they can put up, right, is that the racketeering has ended. Assume the evidence is that it's ended. The enterprise came to an end. So if the enterprise was a gang called the Fancy Boys,
Yes.
the Fancy Boys were all killed,
Yes.
right? And or the leaders were killed. The question is, can the NPA say, we are charging you because for 10 years you were engaged in racketeering, for those who survived, those members of the Fancy Boys who survived? Even though it's ended.
Perfectly, the NPA can still, because it is elimination of crime that you are focusing on.
Yes. And this is the point about the Tikok panel saying it must extend indefinitely into the future.
Cannot be,
Yes.
because
After you may proceed
Because-
to elaborate.
Chairperson, what I was going to say is, for the members of the deceased families of those incidents that have occurred, if you say in 2012 there is no other incident, what do you tell them? Because you should be able to give them an answer. Accountability in terms of the legislation, insofar as my view, the analysis that is in the COG report with respect is incorrect.
I suppose, as you correctly put it, it's also the matter of interpretation. You have to look at the intended purpose of poker, first thing, not so. And I don't know whether you have the same thing in Xhosa or Zulu, Advocate Ngcukaitobi. In Setswana, we will say, Molato ga o bole.
Yes, of course we do.
You have committed these crimes 10 years ago and stopped committing them, but that crime remains.
It remains.
It doesn't get rotten and to say, I'm no longer going to prosecute. That's why we say, Molato ga o bole.
That is correct, Chairperson. Even that rape victim some 15 years ago in the adulthood still remembers that I had gone through this experience that no one is supposed to be exposed to. So Molato ga o bole, definitely we as an NPA, constitutionally we should pursue all molatos, all offenses we should pursue.
Yes. It's called
Without-
Icala Alboli.
Without fear, favor, or prejudice. Yes, Chairperson, Icala Alboli.
Yes.
What do you say, Advocate Ngcukaitobi?
It's called Icala Aliboli.
Icala aliboli.
Yes.
Yes,
It's the same
it's
thing.
the same as Molato ga o bole.
The person who should be told that is the current NDPP. Would gladly think that he doesn't have to deal with this.
I suppose he's a Motswana, he knows that.
Oh, okay.
know, but I'm sure he understands that.
Thank you. Maybe you should just keep the panel report because at some point we'll come back to it. Now, just to back to the definition. So it's planned, ongoing, continuous, or repeated. And then there's another term, participation or involvement. So the legislation requires that you participate actually
Yes.
or you are involved.
Yes.
What does that mean?
You see, Chairperson, POCA was directly aimed at those people who do not participate, who are seen no way, but who fund these terrorist activities. So you fund and but you are never on the scene. But you make it possible for this for this kind of offences to be committed. So you don't necessarily have to participate. You can participate physically and be there, but even those that get involved indirectly, in a way of funding, in a way of supporting, in a way of encouraging, they are included in the definition.
So it's the participants and the enablers.
That is correct, Chairperson, yes.
Yes. In fact, that term is defined very crisply and powerfully by the Supreme Court of Appeal at paragraph 348 of your statement. If you just go up one page.
In S versus Asian,
Yes.
the Supreme Court of Appeal explained the difference between the two offences. The essence of the offence in subsection E is that the accused must conduct or participate in the conduct of an enterprise. Actual participation is required, although it may be direct or indirect.
Yes. Then continue that.
In that respect, the subsection differs from subsection F, the essence of which is that the accused must know or ought reasonably to have known that another person did so.
Yes.
Knowledge, not participation, is required.
Yes. So just to come back to the point we're making, that we are targeting actual participants,
Yes.
direct or indirect,
Yes.
but also enablers.
Enablers and those that do not participate physically,
Yes.
but who make it possible for those conducts to happen. So if you're looking at the fancy boys that are committing robberies, but there are traffic officers who are making sure that they travel safely. They, even when they have their loot, they make sure that they get safer and faster passage through the traffic. Those enablers you can still charge with racketeering.
Yes. So just go back then to Ketomano. This concept of being a participant or an enabler.
Yes.
That's what you call involvement.
Yes.
How do you apply it to those facts? I mean, the big name that we've been talking about, I'm not sure if it's a big name, but it's a common name. It's that of Major General Boysen.
Major General Boysen, in our view, managed the activities of the Ketomena. And, we have instances where he also participated.
Yes.
Yes. So for those incidents where he participated, there are those that he participated directly and those where he participated indirectly. But
how would he have participated indirectly on the facts we've seen?
Let's say let's look at the minimal, those incidences where he was not there.
Yes.
Because what he does is he makes sure that AIA is redundant. We remove AIA from there. We make sure that they have vehicles. We make sure that they have all the resources, and we make sure that they have the legal system or the the police system works on the basis of informers.
Yes.
That are some of the people that you live within the communities that know that crime is being committed. So they make sure Ketomena was structured in such a way that they have an informer network that finds information. You know, even when Ndimande ran to the northwest, to Rustenburg, they were able to sniff and know that he is hiding somewhere in Rustenburg. Even though Makojela was hiding out in the Free State, when he came to Pietermaritzburg to collect money from his taxi operations, they had a strong informer network to know his movement and to be able to track and trace him wherever he goes.
But there is also the other element which we looked at last week, which is impunity.
Oh yes.
These were untouchables.
Untouchables. You know that when you do anything, nothing will come your way. You have protection.
Yes. And at a senior level, could he provide that protection?
General Boysen at the senior level was a cushion that they required to ensure the continuity of the activities.
Yes. Now, it says participation or involvement, and then in any offense referred to in Schedule 1.
That is correct.
And includes at least 2 offenses referred to in Schedule 1.
Yes.
And
so that's why I said you need 2 or more offenses.
Yes. Now, this is Schedule 1 of poker.
That is correct.
Or Schedule 1 of the Criminal Procedure Act.
No, it's Schedule 1. When it refers to a schedule, it's of the same legislation.
Yes. Now, I don't know if we have the Act here, but I think it's necessary to go through the offenses in the schedule.
Whilst you are looking for that, Advocate Mahema, just for clarity, the Section 21E and read with 21A are not mutually exclusive.
No, they are not, Chairperson. Yeah.
Because
they are not mutually exclusive. Because the one is managing and the one is participation in the activities of an enterprise.
Computer.
So we see we charged General Johan Boysen with both 21E and 21F.
Yes. Do you have, you don't have the schedule? Okay, I'll organize a computer to be put in front of you to go to Schedule 1.
Before you do that, Council, now as regards the Katomena predicate offences,
Yes, Chairperson.
in relation to this exclusivity that we're talking about,
Yes.
given that the racketeering charges were withdrawn
Yes, Chairperson.
by Advocate Batoyi,
Batoyi, yes.
and instructions was given that the DPP KZN should proceed with the predicate offences.
That is correct, Chair.
I suppose only in relation to the accused persons who would have been listed in those specific dockets.
That is correct, Chairperson. Who would have actively participated in those, unless if on the basis of common purpose they can link somebody other than the one who was physically on the scene.
Yes, that's where I was going
Yes.
to. Yes. So if the prosecution team in the DPP KZN would then have found that the principle of common purpose kicks in,
Yes.
implicating also Major General Boysen's,
Yes.
given in one of the dockets where he was directly involved
That is correct, yes.
at the scene.
Yes.
then he could be then charged under those predicate offences,
That is correct,
under
Chairperson.
the principle of common purpose.
That is correct, yes, yes.
Thank you, Madam Chair. Do you now have Schedule 1? Of poker?
Oh, do you have the schedule? Thank you. I do, Chairperson.
Yes. I mean, there are 34 offences there.
That is correct, Chair.
Yes. Now, so are those the schedules that are referred to in the definition of a pattern of racketeering offences?
That is correct, Chairperson. It's,
Yes.
Should I read the offense?
No, well, my learned friend just says to me that it's not necessary because we can take it to be common cause that's the schedule.
Yes.
And what you need for poker is participation in 2 or more of those offences.
That is correct, Chairperson. Yes.
Thank you. So you may return the computer.
Thank you. It would be handy, though, to
To keep it.
to keep it and go home with it.
Thank you. Now,
Thank you, Chairperson.
so is the evidence that what you need to establish a pattern is a participation of an individual in 2 or more of those 34 offences?
That is correct, yes.
Yes. And then it says, of which one of the offences occurred after the commencement of this act, and the last offence occurred within 10 years, excluding any period of imprisonment after the commission of such prior offence referred to in Schedule 1. So what does this mean? That you've got a 10-year window to charge a person for racketeering?
That is correct, yes. 21E and 21F. Remember, it only deals with the racketeering offences,
Yes.
and not any predicate offences, if that would be murder or yes.
Yes. All right. So how would that apply to the current scenario? I suppose they were charged even if the charges were withdrawn. So they were charged within a 10-year window.
That is correct, Chairperson, yes. Yes.
Yes. Okay. Now, that takes us to paragraph 351. A distinction between section 21E and 21F. Can you just take us through those and the sub-paragraphs, 351.1 to 351.3?
Chairperson, at 351.1, the offence of racketeering under poker is distinct from and can be charged in addition to any underlying predicate offences that comprise a pattern of racketeering. I usually end at the pattern of racketeering activity, because that's where it ends. But here, pattern of racketeering. It is for this reason that the indictment in Ketomena included charges of racketeering and distinct and self-standing charges of predicate offences.
So just explain what that means when you say, because we debated this with Advocate Batoy, she didn't really commit to a position either way, which is, what is the issue in this case that we are dealing with? Is it only poker or poker plus predicate offences? And then she kept on saying, well, the predicate offences are part and parcel of poker.
Well, the racketeering offences are count 1 and 2. They are self-standing. They are charges by themselves.
No, what I mean is this: in order to prove, in other words, to prove racketeering, you will have to prove the murder. If you are saying the predicate offence is the murder,
Yes.
That's the
So
point I'm making.
you will have to prove all the predicate offences, because by proving the predicate offences, then you'll be proving that over a period of time, you will be showing that it is ongoing, continuous, repeated over a period of time. in that way, then you are now in the element of a pattern of racketeering activity.
So it's a bit misleading to say that this case is not about the predicate offences, because the case is about the predicate offences.
It is about the predicate offences.
Yes. Now, you were still at, sorry, I stopped you at...
Before I
yes,
start with the accordingly.
Yes, yes.
Accordingly, if an accused is not ultimately convicted of racketeering, it does not follow that he will not be convicted of the underlying predicate offences. So if your evidence before court would fall short and the court would not be convinced that there is sufficient for racketeering, the court will still be at liberty to convict
So in
you
other words,
of
if a court
the
says
predicate offences.
you've committed murder once, but I cannot find that it was continuous,
Yes.
you are still guilty of murder.
You're still guilty of that kind of murder.
Yes. I mean, this is where one of the things I don't understand in this case, because they just withdrew everything.
Strange. Very strange.
All right, 351.2.
351.2, Chairperson. Participation in the enterprise and management of enterprise are not mutually exclusive. That is the point that the Chairperson just asked me to elucidate on earlier. 351.2.1, Section 21E caters for a situation where an accused manages the enterprise and participates in a pattern of racketeering through which its affairs are conducted. But the emphasis there is manages the enterprise.
Yes, now, just to come back to this particular case, you had identified, I think, 5 managers.
That is correct, yes.
We can go through them because I need you to explain to the panel why those 5 individuals were identified as managers. They are...
Chairperson, they are on GSM 1-22.
What page?
Page 1-22 of the statement.
Sorry, what paragraph?
Paragraph 71.
Yes, that sounds correct. Yes, that's where you've identified them. Just take us through each one of them and explain why they were the managers.
Chairperson, all of them except Van Tonder were section commanders.
It can't be all of them because Mr. Boysen was not a section commander.
And I was, no, it can't be all of them.
That's why I'm saying just take us one
individually.
individual.
All
Yes,
right.
yes.
Let's start at 71.1. Johan Boysen was the provincial commander of organized crime. But now, instead of being in the provincial office, he then removes Aya, who's the head of Devon organized crime, to whom Ketomena's serious violence unit has to report. He then becomes he assumes the role of Aya. So all of the section commanders then would then report to him, and he facilitates their activity by making sure that they have equipment that enable them to do their work. Now,
I mean, is there evidence that Aya was actually removed? What do you mean when you say he was removed?
he was rendered redundant.
Yes.
So although he was there as the head of Devon organized crime, they would jump him. They would jump him insofar as decisions and everything. When an incident would have happened, he would hear it on the radio, unlike Johan Boysen, who would hear it from the members, from Olivier, and then attend the scene. But Aya would be the commander in name, but not in real fact.
So would you describe him as having been the de facto head?
As the de facto head, yes.
So that covers Major General Boysen.
Neville Eva was known for his attention to detail.
Yes.
So he would make sure that make sure that all the scenes are doctored in accordance with the wishes of the enterprise. He'll make sure that there is a firearm that is placed there. He'll make sure that on every operation there are members that would do the guarding of the scene,
Yes.
protect the outside, and there would be sufficient of the members of the penetrating team. The penetrating team chairperson, remember, are those that I said they are at the door and they identify themselves, and if you don't open as soon as possible, they will make sure that that door comes down and they enter.
So in that sense, he is playing a management role.
He's playing a management role to ensure that that happens. Now, Olivier was the one who was the head of serious violent crime.
Reported to
He's the one that was supposed to be reporting to Aya.
To Mr. Ayer, yes.
Yes. Now, instead of reporting to Aya, he reports to Johan Boysen. Lockham was also one of the commanders who also made sure that all the team members are available whenever they are required. Whenever there is information that comes from the informer of any of them, then he would make sure that whoever has to be on duty gets on duty, and he would ensure that they have a sufficient number of officials at that activity to deal with whatever challenges that comes out there.
The last one is Mr. Van Tonder.
Mr. Van Tonder was the one who was he's predominant in all the activities. He's the one who was mostly present in all of them. But he was a trusted soldier of Johan Boysen. Johan Boysen will trust him with all the information, and he will make sure that whatever activities that they have planned are executed to the satisfaction of the wishes of Johan Boysen.
Yes, okay. Thank you. So in that sense, these were playing a management role.
They were playing a very crucial management role of the activities of the enterprise.
It sounds like there were different facets, but nevertheless, it's management facets, because
That is correct,
one
yes.
is managing informers, one is managing the actual scenes, one is making sure that the logistics for operations are
Yes,
undertaken, and then
yes.
there is the overall supervisor.
Yes. And the overall supervisor also ensures that you manage the, what do you call it? The reputation of this team, so that also insofar as the media is concerned, there is no negative reporting about Ketomena activities.
Yes.
You have your Karima Browns who will report negatively about Mr. Chauke and I in the media. You have all of that, that makes sure that.
So who was responsible for making sure that you receive positive media coverage? The unit receives positive media coverage? I didn't get that.
No, I'm saying Johan Boysen would also make sure that the reputation of the Ketomena remains intact.
I see.
To ensure that there are those in the media houses that would report in accordance with the narrative that they were pushing. Your Karima Browns, there are a number of them. There are, I got the Coke report as a result of one of the media people asking me what my comments are. I've never received a copy from the NPA, and when I received it, then I make sure that I share it Advocate Chauke and most of the other teams that are referred to in the report. So very strange that a report that deals with the work that you've done within the NPA is not only the compilation thereof is not only shared with you, but up until finalization, I hear about it from the media.
Yes. Thank you.
But then why would you think that that information would have been given to the media by Major General Boyce?
Chairperson, I'm not saying it was given by Major General Boyce. All I'm saying was it's a report that was generated within the NPA about work that I have done myself. So I expected some stage to say, Mama, you're saying there's evidence. Where is this evidence? Show me. The dockets are here. Come show me where is this. Where is this? Particularly with the Rodney Dikok, who was very close to me. I had expected him to pick up a phone and confront me about anything. I would not go to Cape Town and leave Cape Town without visiting Rodney Dikok in Cape Town. So I would have expected if there is anything that is within the institution that affects the moving of his eyebrow, he can pick up a phone and say, Maima, what is happening here? Can we sit down here and talk about it? We could sit down and talk about anything and everything. But he compiles a report about this. There are things that I have done that he doesn't understand, that he finds strange, but he doesn't confront me with that. So I found that very strange.
So the disclosure could have been made by anyone within the NPA.
That is correct, Chairperson. But all I'm saying is, Audi Alterem Patem says, you hear the other side. Now you compile a report like this where you rubbish the work that I've done, yet you don't give me an opportunity to explain the rubbish that I've done. So I would have expected at least to say, what is this thing? It doesn't make sense. Because as lawyers we differ, judges differ, but at least engage. Hear the other side.
Maybe let's just talk about process and not about expectations because of the relationship that, that you have
with
or
him.
You had with him.
Yes.
When one reads this report, it appears like it's a product of a review of the work that was done by your
by my team, yes.
That's right.
Chairperson.
Now, what is the process in the case where someone is in the NDPP, in particular, the NDPP herself or himself, whoever would be occupying the position?
Yes,
what is the process if someone wants to review the work that you have done?
Chairperson, if one looks at section 179 from subsection 2 to subsection 5, in fact the review powers of the NDPP are in section 179 sub 5. The review would be instigated by a written complaint or either a complaint from an accused person or a complaint from a family of the deceased. A participant would complain, and then a team would be put together to review the decision that was taken.
But now I think we must talk about a review that is being done at the instance of the NDPP without even any complaint having been lodged.
1795.
But upon perusal, the NDPP, like it is the case in this particular case, that it was done at the instance of the NDPP.
Yes.
Let's just talk process. What is the process? What are they supposed to do, especially in relation to the prosecution team? Thank you.
Chairperson, what I would have done if the national director had asked me to do this, I would
No. I think the question is not what you would have done.
Oh.
It's what is the
what
process?
the process is.
Yes.
Yes, thank you.
Well, I would have followed the process, but the process is a team is put together, and The team then will consider and evaluate what is the evidence that is available. Now,
Mr. Mayema, I think we're going sideways again.
are we?
You've told us that the process is outlined in Section 179, subsection 5 of the Constitution.
Yes.
What does that section say? You can find the provision and read it for us.
Section 1795D. The National Director may review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified by the National Director from the following persons: from an accused person, from a complainant, from any other person or party whom the National Director considers to be relevant. Now, in fulfilling the responsibilities in Section 17795D, the National Director would then put up a committee, a team.
But I mean, was this process here followed? I mean,
No, it wasn't followed.
this
It wasn't followed. There is no representations within a period of time from an accused person, from a complainant, or from any other person that the National Director considers
Yes.
relevant.
Thank you, Advocate Mayema. It will help if you were to just try to answer the asked questions.
It is difficult, Chairperson, when you when you sometimes have more information and instead of
Your witness will tell you that one day.
Thank you.
Thank you, Chairperson.
Thank you.
Thank you. I'm sorry, I'm going to take you a page back because I was slow in raising my question. Advocate Mayema, you listed the 5 managers or the 5 people that you regard